Hello, and good morning, everybody. Okay, so we're just getting set up. I got two places that I believe we can watch this, but there's some information that has come out regarding this. This was supposed to be a hearing regarding the DNA testing. Apparently, they have come to some kind of agreement on that, but there's still going to be a hearing on other matters. They're going to be discussing today. Lori's lawyers want to argue that the language in the grand jury indictment against Lori needs to be more clear. They're basically saying that the grand jury indicted her on a series of charges instead of individual charges, that they shouldn't have been grouped together. They were worded wrong, stuff like that. Jim Archibald is one of her defense attorneys, and he believes the two counts listed in the indictment are complicated because they each include two separate allegations, according to, he says, the way the documents are or have been filed. So counts 1 and 3 filed on May 25th are each labeled conspiracy to commit first degree murder and grand theft by deception. So he's saying they shouldn't have been grouped together. Now, the defense is arguing that the jury could be confused on how to rule for the two crimes when both of them are included in one count. So he's asking Judge Stephen Boyce to reconvene the grand jury to deliberate and amend the indictment so both alleged crimes are tried on their own count. Okay, so that's what we're going to be hearing today. Now, Chad Daybell and his attorney, John Pryor, apparently are not going to be at the hearing this morning. Lori and her lawyers will be. They, along with Lori's attorneys, were originally set to discuss the motion about the DNA testing because it's going to be consumptive, which means the prosecution would consume some of the evidence. There wouldn't be anything left for the defense to test if they were to do their own testing. But an agreement was reached with the prosecutors, and I guess that's on its way to being done now. So that is no longer an issue, which is good. Now we know this DNA testing can be done, get going on it. So, but what they are still fighting about is this indictment on Lori. That's what we're going to be hearing. So I do have it open here. So when it starts, we will be able to see it now. Let me just see here. I can't blow this up. I'll have to show you guys this either on my community tab or in another live because I don't have it saved yet to be able to blow it up. But they did reach an agreement on the DNA, which is good. I would have liked to see the two of them eye to eye. This just came out last night after I'd already posted my thumbnail and everything else. So I got notice of this morning that this had been done. Apparently it came out last night. So I am waiting for this to start. Let me just see here. Okay, hang on a sec. I'm just listening to something else here for a second. Okay, so I'm listening to another verified site here, and they're saying that they doubt that this is going to go through as scheduled in January. So they're also saying this is on Court TV. You guys, they're basically going over what's going to be happening today, and they're saying too that They don't think that these charges should be grouped together and should have gone in front of the grand jury together. You didn't miss nothing, Joe Wiley. Court hasn't started yet. I'm just commenting on other things that I'm hearing other places from different sources here, news outlets. And Court TV is basically talking about they don't think that this is going to go to trial in January as it's been scheduled, which really brings up another point. Let me just pause this for a second. Which really brings into question again with Lori not waiving her right to a speedy trial. They said it's only going to be a couple months, so it really doesn't matter. We're not impeding on her that badly. It's only a couple months. Now, if this is dragged out again, that may be brought into an issue again, because now she wanted her trial to go ahead in October. And they said, well, it's only a couple months, like no big deal. But if this is postponed again and not go forth in January and is rescheduled, say, for next summer or next fall, then she has a case, and she could very well get her case thrown out on appeal. She has a right to a speedy trial. Now, if the courts find that the 2 months between when her trial would actually happen and January, when it was, it could be scheduled together so they don't have to repeat evidence and stuff like that and get both trials all done at the same time. 2 months is really not a big issue. But what comes an issue, and I'm going to say this right now, what comes an issue is if that is again prolonged. She's going to have a case on appeal. So let's just see what happens here. Mary. Okay. Okay, I'm just going to mute this until it starts, so I'm not getting confused with speaking with you guys. Yeah, they may have to do a whole new grand jury sitting, or they may just be able to send it back and have them separate the two charges. But there's the charges of conspiracy and the charges of murder for JJ, and then the charges of conspiracy and the charges for murder with Ty Lee. Then there's the conspiracy and the charges for the murder of Tammy. They would have, those are three, they're saying those are three separate cases. And even within those three cases, the conspiracy and murder shouldn't be grouped together. I mean, have to go back and watch my reads on this, right back to the very first one when this happened, before their bodies were found and everything else. What came out in my reads then slowly came to light. Once Lori was arrested, there was a read that I did that said Chad was going to flip on her, and I still do believe that. I can't remember everything that came out in the read, so you'd have to go back. They're all listed in my video tab. I think I do have a collection where you can find all of the Lori and Chad Daybell videos all grouped together. So we're just waiting for this to start. It's supposed to start in about 5 minutes. I've got two separate things open here. I also got Judge Boyce here. We'll just see. We'll see where I can get it the best, and that's what we're going to go with. But either way, you guys will be able to see it. So what does flip on someone mean? That means that instead of protecting them, that you're going to throw them under the bus and blame everything on them. You had nothing to do with it. Chad, I think, is going to say, look it, her brother and her were at my house. I don't know what the hell they were doing. Blah, blah, blah. Wasn't me, wasn't there. And I think Lori's going to say the same thing about Chad. So, okay, so we're getting underway here, you guys. It's about to start. So let me get sure. Oh. They're showing a commercial here right now, and it's really loud, so. I'll wait till this commercial plays through, and then I'll show it on screen. Good morning, everybody. Good morning, Rosie. Just trying to get through these commercials, you guys, before we start showing it. Just waiting for it to start, you guys, and then I'll put it up on screen. Oh my God, they got like tons of commercials here, you guys. I think they're going to play them right till the time it starts. Come on. Still commercials, you guys. Okay. Okay. Let me just get the sound on here. Okay, it hasn't started yet, you guys. Whoops, why is my sound off? Hang on. Still waiting for it to start. The DNA summer has been decided already. They've made an agreement on it, so the DNA testing is going to go forward. What we're going to hear this morning now is still other things that they're fighting over regarding the charges being grouped together and charged by the grand jury all together instead of separately, stuff like that. So that's what we're going to be hearing. And it should be starting any minute, you guys. Can I ask you guys right now, please don't be mentioning other channels, other creators, other places. If you choose to go and watch it somewhere else, you can go right ahead, but you don't need to mention it in here. So they're also asking to make that the grand jury comes out with probable cause affidavits for each charge. Summer, if I've already timed him out, if he starts up again, just block him. No, they're not trying to separate the cases. They want Lori's charges to go back to the grand jury because they said that the charges as charged in one probable cause affidavit and charged together shouldn't have been done that way. That they would need to have probable cause on each charge individually and not all grouped together and using one probable cause affidavit. Yes, I'm going to have the video up as soon as it starts. It hasn't. Okay, it's starting now, you guys. I'm going to get it up. Let me just share my screen. I don't know why I don't have any sound here yet. It just did come up. Why it is not? Hang on. Let me just check over here. I'm just getting seated now, you guys. When I get the sound on, I will transfer back over. Summer, seriously. But he didn't know what he was doing. It still hasn't started yet, you guys. As soon as it does, I will click back over. It's just there's things that will be copywritten here, so I don't want to get any strikes. And it's saying it's going to start soon. Lori is in court. She's got her hair up in a little ponytail right on the top of her head. You guys are going to see this. Don't worry. As soon as it starts, I will click over to it. But she's all smiles and happy, and wait till you see this. Okay, so they just said right now the camera is on the seal because they can't show court proceedings until the judge is already seated on the bench. There was an order that I seen. Let me just mute this for a second. There was an order that I did see that granted a pool camera, but they weren't allowed to show the court reporter, the judge, and somebody else. There was somebody else too that they weren't allowed to show. They weren't allowed to show the judge coming into the courtroom. They weren't allowed to show the judge, stuff like that. So that's why we're not seeing the court right now. They're not allowed to start showing the court until the judge is seated. Okay, here they go. Okay, here we go. I'm going to share it with you. Whoops.
We do have.
Okay, let me know if you can hear it, everybody.
Governing conduct both in the courthouse and the courtroom. I would reiterate.
Oh, wait a minute.
Prohibitions that are contained in the order governing courtroom conduct. On page 2 of that order that.
Okay, hang on a sec, you guys.
And I'll just read that.
Hang on a sec, you guys. I'm getting back feed on mine. Hang on a second. Okay. He's just going through saying that if anybody in the courtroom uses a cell phone, they'll keep it. Okay, press 1, please, if you can hear it. I've got this on full volume.
From this courtroom, if you have not been previously authorized to do so as part of the media in orders the court's entered, is likewise prohibited. So I would.
Can you hear it?
Public, please comply with that order at all times during this hearing.
Yes, it is low.
Time then, Mr. Wood and Ms. Blake are here on behalf of the state. The defendant, Ms. Vallow, Daybell, is here represented by.
I've got it full volume, so turn up your volume, you guys.
In terms of these motions, to clarify for the court, who's intending to argue the motion on behalf of the defendant, counsel? All right, Mr. Thomas.
There's nothing I can do, you guys, about the volume. I've got it, as you can see, all the way up.
I will, Your Honor.
Mr. Wood will present argument for the state.
So please turn up your volume.
That we did previously have scheduled a motion in regards to consumptive DNA testing that was set for today. The court has received a stipulation and an order which I've signed that resolved that issue. And so that is not being taken up for hearing this morning based on the order entered on that. What remains then for the court today are 2 motions as they relate to the charges that are contained in the indictment. 2 separate motions, one as it relates to aggravating factors, and the other motion as it relates to counts 1 and 3 with the conspiracy charges. We'll hear argument on those motions. I will indicate one other procedural matter that upon completion of this hearing, the audience will be instructed by the security here in the bailiffs as to when you'll be leaving the courtroom for security purposes. So please remain seated until you're instructed to. leave the courtroom upon the conclusion of this hearing. So going forward to the motions now, let me first just ask Mr. Thomas, is the defense ready to proceed with your motions?
Yes, Your Honor.
All right. And is the state ready to proceed this morning, Mr. Wood?
Yes, Your Honor.
Very well.
Oh, that
First motion
smile.
I'd like to take up then is the motion that was filed on July 12th, entitled Motion to Remand to Grand Jury for Probable Cause Determination as to Alleged Aggravating Factors. Why don't we start there, Mr. Thomas? I've reviewed your motion and briefing. I've reviewed the state's response as well, and if you'd like to present argument on that at this time, you may.
Certainly, Your Honor. Thank you. We would also, we have filed a motion to incorporate federal and state constitutional grounds in support of future motions and objections. That has not yet been heard. So I would just like to put that on the record that we are relying upon that motion, and we're relying upon the 4th, 5th, 6th, 8th, and 14th Amendments of the United States Constitution. There are about 70 cases that are cited in that motion. I can read those off for the clerk or for the reporter if the court is okay with that, or would the court like me to?
Well, we don't have that notice for hearing today, Mr. Thomas. I mean, I can take note that it's been filed and understand the request you're making there in terms of making any specific finding or determination.
Right.
It's not set for hearing. The motion's been lodged in the case, and I don't think it's necessary to put all the authority into the record on the oral motion at this time unless you think that's necessary. So it's up to you.
And I don't think it's necessary. I just want to make sure for appeal purposes that the court is aware that we are relying upon those constitutional amendments.
Okay, and I do understand that those are incorporated into your defense here, and we'll be considering those federal constitutional protections as well in this case.
Thank you, Your Honor. So the first motion that we're going to argue today is the with regards to the aggravating factors. Your Honor, we believe that that there should be a probable cause hearing on these aggravating factors. Pursuant to our motion, we indicated that those aggravating factors enhance, if you will, the penalty, and therefore they are part of the punishment here. We understand the state's position, and we understand that the state's position, the Supreme Court of the state of Idaho's position, is that Abdullah is controlling law here. And we get that, but we are of the opinion that that there should be probable cause hearings on each of these aggravators for several reasons. One being that it narrows down the possibility of us having to prepare for a trial on an aggravating factor that doesn't fit, that doesn't meet the probable cause standard. There are other reasons that we've noted in our brief. We'd ask the court to consider those. As I said earlier, we understand that Abdullah is the law of the land here in Idaho, but as the court is well aware, especially this year, where the Supreme Court ruled to overturn Roe versus Wade. Roe versus Wade was the law of the land for a number of years, and then through time and change, they decided to overturn that. That was a landmark case, and we would just like to, for appeal purposes, put that on the record that we believe that it should be a probable cause standard as far as these aggravating factors go, and we would rely upon that for appeal purposes. We understand that the court is likely to deny our motion on that, but we would like that to be part of the record. And that's all we have on that.
All right, I have a question then, Mr. Thomas. If under your motion, who would make a probable cause determination? Are you suggesting, because this case came about as a result of a grand jury indictment, are you suggesting it would need to go back through another grand jury indictment or go through some sort of a hearing similar to a preliminary hearing where a magistrate potentially or me would determine probable cause?
You know, that would be a hybrid issue, and I don't think that would be appropriate. I think that it should go back to the grand jury to have them to decide whether or not this should move forward. I'm not sure that the Idaho statutes and constitution allow for that hybrid, bring it back to a grand jury or bring it back to a preliminary hearing and let some a magistrate or your honor to decide whether those are probable cause or not. I'm not sure that it would really matter, but I would think that bringing it back to a grand jury would be the more appropriate way to do it, since they were the ones who found the probable cause on the alleged crimes. I would ask that the court require that they also find probable cause upon the aggravating factors.
All right, thanks for the response to the question, Mr. Thomas. Mr. Wood, what is the state's response on the motion for further probable cause determination on aggravating factors?
Thank you, Your Honor. I'll be brief. As Mr. Thomas has pointed out, there is controlling law on this issue, directly on this issue in State versus Abdullah. It's a 2015 case, capital case, where the death penalty was found. And I'll just, this is in my brief, but I'll just read from it very quickly. This is a direct quote from that case. We also hold that there is no constitutional requirement that the state present evidence demonstrating probable cause for each aggravating circumstance to properly notify the defendant of its intent to seek the death penalty. And so, as Mr. Thomas did state, that is controlling. It's the Supreme Court of the state of Idaho. That analysis starts, their analysis starts with a discussion of Ring versus Arizona, which is the case that found that death penalty needs to be found by a jury. And that case has been interpreted by some to provide that there should be a probable cause finding of aggravating factors, even though the Supreme Court did not actually find that. Abdullah goes through that analysis and comes to the conclusion that the Supreme Court comes to the conclusion I just read. Where the Supreme Court has found that, where it's directly on point, I think this decision is already made for the court. I understand Mr. Thomas's argument that it's for appeal purposes, and we understand that. But as for this case, and under the current law, this is an issue that's already decided by the Supreme Court. There's no need for probable cause to be found of the aggravating factors. Idaho law determines how those aggravating factors are listed and how that notice of intent is given, and that has been upheld in Abdullah. And so for today, I think Mr. Thomas said it well. For purposes of appeal, they've raised the issue, but as of for this case today, I think this decision's already been made by the Supreme Court.
All right, thank you for the response, Mr. Wood. Mr. Thomas, do you have any rebuttal argument to make?
No, Your Honor.
All right, the court's considered the motion then at this time, given the nature of the case, in lieu of making a finding or ruling from the bench, the court will take this matter under advisement and will issue a written decision on the motion. That will be lodged once we've completed the research and written the decision on that. So that first motion will be taken under advisement. Mr. Thomas, then if you'd like to present argument on the second motion, and that was your motion filed also July 12th, to remand the indictment to the grand jury for further proceedings, and in particular stating your objections to the listing of the offenses in counts 1 and 3 of the indictment. If you'd like to present your argument on that motion at this time, you may.
Thank you, Your Honor. Our main argument revolves around counts 1 and 3, that they're confusing to the jury. They would be confusing to a jury when they have to find this after the trial to find this these elements. And I see that the state is saying that the crimes of murder and the crime of grand theft are not necessarily the crimes in the conspiracy. However, this doesn't make any sense because the conspiracy to commit murder and the conspiracy to commit grand theft are two separate conspiracies. And I'll go through that in just a bit. But we do believe that it would be confusing to a jury to be able to figure out what elements were met and when the elements were met and to what extent the elements were met. The burden is high. The burden is beyond a reasonable doubt. If they meet some of the burden at a different standard, perhaps a probable cause standard, or perhaps a more likely than not, or a different standard, that would be severely detrimental to our client. So I think one of the things that we need to think about in reviewing whether or not these charges, conspiracy to commit murder and grand theft in count 1 and count 3, should be split off or bifurcated. I think we need to say, when does the conspiracy end? Well, one would think that the conspiracy to commit murder would end when the alleged murder occurs. That would be the end of the conspiracy. The state has pled in count 2 of the indictment that the murder of Tyler Ryan occurred on or between September 8th and September 9th. So that would be the end of that conspiracy. The conspiracy to commit the crime would have been completed, and the conspiracy to the murder would have been over. One would think that the conspiracy to commit grand theft ended when the grand theft was over. And the pleadings in count 7 of the indictment indicate that the grand theft would have occurred after the murder. The murder of Tyler Ryan was pled to have allegedly occurred no later than September 9th, and the murder of J.J. Vallow in count 3, that murder was alleged to have been committed on or before September 23rd. And so the grand theft was alleged to have occurred pursuant to their indictment between October 1st and January 22nd. So the conspiracy, while we can have a before portion of the conspiracy, October 1, 2019, and January 22nd, 2020.
Oh, thank you.
And so they're saying that the conspiracy, while it could have possibly developed earlier, it could not possibly have ended in the same time that the conspiracy to commit murder would have ended. So the conspiracy to commit murder would have ended at the very least, at the very most, on September 23rd. The conspiracy to commit the grand thefts were committed between October 1st, allegedly, and January 22nd of the following year. And so those don't line up.
Well,
So-
Mr. Thomas, though, can't you have an ongoing conspiracy of different offenses? I mean, a classic conspiracy is like a drug conspiracy where somebody's doing a delivery of a controlled substance, and then a week later another delivery, and a week later another delivery, and that's all part of a grand conspiracy charge that would have multiple offenses. Isn't the time frame open through all of these charged offenses?
Sort of, but not after the conspiracy to commit murder. Once the murder is committed, there is no conspiracy to commit the murder. There's maybe a cover up or a conspiracy to I don't know, after the fact, some sort of other charge. But once the conspiracy to commit murder, once the murder is over, the conspiracy is over, right? I don't see how that could go anywhere further. And so with the conspiracy to commit murder over, I think that's where that charge ends. The conspiracy to commit murder ends at the end of the murder. And so I don't think that they can tag on a conspiracy to commit grand theft as part of the conspiracy to commit murder. And in fact, the state says that in their brief, they say that Idaho Code 18-1701 gives the punishment for conspiracy as punishable upon the conviction in the same manner and in the same extent as provided under the laws of the state of Idaho for the punishment of the crime or offense to which the combined had committed. And in layman's terms, I think, if I'm reading it correctly, and I may not be, but it says in layman's terms, this is what I feel, that if they find a conspiracy to commit murder, then the punishment is death. And that is the conspiracy to commit. That's the conspiracy. If the conspiracy to commit grand theft, the punishment would be up to 14 years in prison. And so it sounds like there are two possible punishments to this one conspiracy, either death or life in prison or 14 years in prison. And so to me, it sounds like there are two conspiracies. I understand the state's position where they say the conspiracy is the crime, not the murder and not the grand theft. But when you make a statement like that, you have to back it up with the facts that say, well, yeah, once they've committed the conspiracy, we have to now go to the punishment. And their punishment doesn't meet the crime. The conspiracy punishment is one of 2 or 3 different punishments, either death, life in prison, or 14 years. So it could be possible for this jury to find some elements of the grand theft, some elements of the murder, and say, maybe they met all the elements. We're not asking the court to, I did ask the court to strike the pleadings, but that was mostly in alternatives. Our main issue is we don't want to have to do this again. We don't want to have to come back before the court after the trial's over and it goes up on appeal, and the appeal court says we couldn't make heads or tails of what was going on with this conspiracy charge. And so we think that it's just easier for the court to say, you know what, bring it back to the grand jury, have them split it off, have them do one conspiracy to commit murder, one conspiracy to commit grand theft. It's just that easy, and therefore it brings the jury into a position of we find them either guilty or not guilty, not, well, guilty of the grand theft, but not of the murder. And it just makes it so that there's too many questions for the jury. I'm not saying that the jury isn't sophisticated enough to sort through that, but I've been practicing law for 20 years, and this particular charge baffled me, and I had to work through it, and I still am having issues working through it. And this is what I do for a living, so it just makes it all the more difficult. Another point, Your Honor, is that this is just fundamentally unfair. The state argues in line 5 of their jury instructions, says, further, the explicit language by establishing that the state needs to prove that the defendant intended that at least one of the crimes would be committed. They emphasize the words, at least one of the crimes. So in my mind, that infers that the defendant need not even contemplate the commission of the murder, only the grand theft, or vice versa, only the grand theft and not the murder. And so I have issue with the state saying, hey, we can lump all of these things into one conspiracy charge, and as long as they find one of those conspiracies, then the conspiracy is met. And so if we're doing that, then you're asking the jury to find not only was it murder, or was it grand theft, or was it something else that the state is going to come up with between now and the trial, and how do we punish that? And so now we have to go back to the jury and say, okay, so which conspiracy did you find? Well, we found that there was conspiracy to commit grand theft, but not conspiracy to commit murder. Or we found that there was conspiracy to commit murder, but not conspiracy to commit grand theft. And so now we're looking at, it just jumbles it up, and it doesn't make a lot of sense to do it that way. And we're bringing it before the court because we believe that we're just looking for a fair trial. We just want the jury to be able to go back to the jury room and say, yes, this is the conspiracy. The conspiracy is to commit murder, or yes, this is the conspiracy. The conspiracy is to commit grand theft. That's all we want. That's all we're looking for, is a yes or no answer that the jury would need to come back with. Further analysis would just be, I don't know that it's appropriate, and I don't think it's fair for the jury to have to do that. The state further takes issue with my 8A argument. They indicate that 2 or more offenses may be charged. I say that the 2 or more offenses may be charged on the same indictment. However, Criminal Rule 8A indicates that those charges need to be separate counts. And so the state's attorney says that there's one conspiracy for two different crimes, and I'm not analyzing that, and there's no analysis to that. Well, my analysis is, Judge, the state's wrong. The state needs to realize that, yeah, this needs to go back to the grand jury, and it needs to be conspiracy to commit murder, conspiracy to commit grand theft. The state goes on to make an untimely argument, that we are untimely in our arguments. We would ask the court to rule on the merits of the case and not on the untimeliness. The state has, in my opinion, the state has waived their right to make this untimely argument. We got their response to this motion just 6 days ago, which is in my opinion, untimely. I think a 7-day notice is pretty standard around the state. Also, the state, the court is aware of how much discovery is involved in this, sorting through that. And perhaps, I wouldn't even say that normal cases we would be able to find this within the 28-day time frame that the legislature has or that the rules have established. But this particular case, is far in excess of the time frames and the process and the time needed to just digest this case and the discovery. And the state, when I filed my discovery my discovery request on April the 18th, the state failed to respond in a timely manner. They responded timely, I guess I should say that, on May the 2nd, which would have been the 14 days, but they responded by telling me, oh, by the way, we'll get you your discovery within 14 days of May 2nd. So they were untimely on that. And yet they're telling me that I need to, I was untimely on filing this motion and that I should have come to the court for relief and request. I would also note that the docket indicates that the court didn't release the testimony of the grand jury until June 21st, 2022, which is far beyond the time frame for us to file a 12B motion, which I think is excusable error based on the fact that we didn't have the information that we needed to dig into the indictment and dig into the things that we needed to do. Your Honor, in closing, I would just say to the court, and I know that the court is well aware of this, that a person's life is on the line. The prosecutor for the state of Idaho represents the interests of everybody in the state, and that includes the defendant. They are duty-bound to look out for the procedural interests of the defendant, and what they're arguing, in my opinion, Your Honor, is wrong. The state's attorneys here are here to seek justice, not just a win, and they're here to protect the Constitution and the rights of all those in the state of Idaho, including those that they're prosecuting. And so I believe that the appropriate way to deal with this indictment is to return it to the grand jury and just have them split the two conspiracy charges so that it's easier for a regular jury, for a trial jury, to understand and to sort through this. Thank you.
All right, thank you, Mr. Thomas. I'll hear response from the state. Mr. Wood, I'd like to start off with the issue raised there at the end that was raised in your responses to both of these motions, that they were failed to be filed timely under Criminal Rule 12B. And let's start there and then move forward with the substance of this motion. So if you'd like to present any argument at this time, or notify the court if you're still holding on to your objection on the timeliness issue.
Thank you. Your Honor, we do maintain that objection. That's why we put it in our briefing. We do understand that 12B is a rule in which the court has a large amount of discretion to find good cause or reasonable neglect. However, the reason why we filed that is in neither of the defendant's pleadings was any good cause or reasonable neglect provided for why these were untimely. I do take issue with the idea that the state was late in discovery. We had already provided all of the discovery to co-counsel, and so I take issue with that. Yes, we do maintain that objection, understanding the court has wide discretion on that issue.
All right, the argument on that. The court's reviewed that objection. It's made under timeframes that are set forth in Rule 12. In particular, Rule 12D of the Idaho Criminal Rules indicates motions under Rule 12B must be filed within 28 days after the entry of a plea of not guilty or 7 days before trial, whichever is earlier. These are not within that time frame. However, that Rule 12D also has an important final sentence. The court may shorten or enlarge the time and for good cause shown or for excusable neglect may relieve a party of failure to comply with this rule. I've considered that objection and looked at the objection as well as the discretion built within the rule under 12D. And I do find, as it relates to both these motions, that good cause has been shown for the timing of the motions. One is the complexity of the case and volume of discovery. There's been delays through no fault of defense counsel with their client having been found incompetent for some time and then returned to competency for further proceedings. The court would note that trial is not scheduled in this matter until January, so we're still significantly before the time for trial. The court would also note that we discussed specific dates for the calendaring of these motions, along with the input from the state as to when these would be appropriate to be heard. And that rule goes to the filing of the motions, not necessarily the hearings, but given that determination and my discretion, I think it's important that these issues be determined on the merits and not procedurally under the rule. And so in my discretion, I am finding good cause exists for a factual and legal determination on both of these motions today. And so I'll deny the objection as it relates to timeliness. Finally, on that discovery issue raised, I don't take that into consideration at all because there's been no motion to compel filed or any other notice to the court that that's at issue. So with that ruling made, Mr. Wood, if you would like to now present your response as to the merits of the motion on counts 1 and 3.
Thank you, Your Honor. Going through the defense's motion, it seems that the primary concern is this is going to be confusing to a jury and unfair. The state just fundamentally disagrees. The defense's argument rests on what appears to be a false premise that a conspiracy to commit multiple crimes is in fact multiple crimes. I've outlined this in my brief, so I don't want to go over it word for word, but I just note that multiple cases have held, and this is just a few of them, that the conspiracy is the crime. It's one crime, however diverse its objects, and that's very important language. You could have a conspiracy to commit completely different crimes. The state believes that in this case there are 3 conspiracies. There are 3 agreements. The conspiracy, the crime of the conspiracy is the agreement and an overt act to further that agreement. Whether that overt act is otherwise illegal or not, it doesn't have to be. And so the state believes there are 3 criminal agreements. One was to murder Tylee Ryan and to steal the Social Security money that was allotted to her. One was to kill J.J. Vallow and to steal and continue to collect the Social Security funds that were allotted to him. And those are the 2 counts that are at issue today. We do believe they are linked. And so they aren't completely separate. They are linked together, and we believe that the jury will find that there was this agreement, that they agreed to commit those 2 crimes. When we talk about the elements...
Let me ask you a question on that, Mr. Wood. Are you saying it's a single conspiracy that envelops counts 1 and 3, or
No.
is count 1 a conspiracy and count 3 is a separate conspiracy?
Yes.
And I know there's a 3rd conspiracy charge in the indictment under count 5.
Right. I want to be very clear. We believe there are 3 separate conspiracies.
Okay.
And so looking through the defendant's pleadings and listening to argument today, they speak a lot about the elements. Well, the elements for the conspiracy, we don't have to prove the elements of the underlying crime for a conspiracy. I've listed the jury instructions in our briefing, and the substantive showing that the state needs to make and the jury needs to find beyond a reasonable doubt is that they agreed to commit a crime or crimes, and the jury instructions have this written right in. They have the S for crimes, a crime or crimes. And that the defendant intended that at least one of those crimes would be committed, and that one of the parties to the agreement performed at least one of the overt acts that are listed in the indictment. Those are the elements of the conspiracy, not whether or not the murder was completed. You don't even have to complete a crime for the conspiracy to be found. And so
Let me ask another question on that, Mr. Wood. When you're instructing a jury, do they not have to be told what the underlying elements of a crime are? In other words, the common lay person may well not know the difference between grand theft, burglary, and robbery. So if you just throw in, for example, grand theft and say, was there a conspiracy to commit grand theft? Does the jury have to be told, well, here's what a grand theft is under Idaho law, and lay out each of the elements so you make sure that they know what the underlying crime is that was part of the conspiracy?
I believe so, but even if that's the case, they don't have to find the elements of the underlying crime. For instance, if person A and person B agree to kill person C, they've made the agreement, that's the first part, and one of them purchases a gun and they drive there, and then they get stopped by the police, they've still completed the crime of conspiracy, because the crime is the agreement, and then taking an overt act in furtherance of it. It's not the completion. It's not the completion of the crime. The crime is the agreement, and the case law on that is clear. And so even if the jury is entitled to see those elements, which they will in this case because they've been charged with those separate crimes as well, they don't have to find those elements. They don't have to find a single element of those crimes to find the crime of conspiracy. I found no case law to suggest that's the case. And I don't believe there is any case law to suggest that, because the crime is the agreement and the overt act. In terms of, Mr. Thomas raised the issue of when does it end? Well, and the court pointed out there can be ongoing conspiracies. And we do believe that the evidence here is going to show that it ended when Social Security stopped paying out the money that was being stolen. And we believe, and so the conspiracy doesn't necessarily end when one of the crimes is completed. If there's multiple crimes, it ends when the whole conspiracy ends. And I don't think that's confusing. I don't think a jury is going to find that confusing. And so again, Your Honor, I go back to the point that the law isn't unfair because it's bad for the defendant. That doesn't mean it's unfair. The law is not unfair because it's not in the defendant's favor. No crime is in the defendant's favor. And so I take issue with that agreement that this is fundamentally unfair. I don't believe this is fundamentally unfair. I think these are charges based on the evidence provided to the grand jury. They didn't have a problem with it. They found it. And so if they can find it, I think we can put it in front of the pettit jury, the trial jury.
Mr. Wood, I do have a few more questions on that, and I'll
Sure.
just let you know, before the motion was filed, I've looked at these two counts a lot of times because I have not determined whether or not they're correct or incorrect, but I will say I haven't seen charges that had multiple crimes that were unrelated like that in a single count. And thinking in terms of going forward, my concerns have been two. Number one, how do you instruct a jury with a jury instruction? And maybe we'd start there. Do you believe a jury instruction would require a definition of all elements of both offenses if you're going to tell a jury they conspired to commit these two crimes? The way the indictment is written, it's in the conjunctive using the word and, conspiracy to commit first-degree murder and grand theft. So that tells me the jury's got to find both of them, not one or the other, is the way it's written. And so do you think within a jury instruction you've got to say, and here's what a first-degree murder is, and here's what a grand theft is, and is that all part of, now we're getting to a very, I can see a very large and cumbersome jury verdict form or instruction on how do you find count one?
I have seen no case law or authority that says we have to provide the elements of the underlying crime to the jury. If it's out there, then it's out there. But I've seen, in my research on this issue, I've never seen any authority that states we have to do that. And I think the rationale behind that is those underlying crimes are not the crime. they're already being charged with the murder and the grand theft separately. At least Mrs. Daybell is charged with the grand theft separately. And so the jury will have those elements already anyway in this case. So if that is a concern for the court, I think it's already taken care of because the jury's going to see the elements of those crimes when they have to decide on the murder charges and the grand theft charges. I actually think that we are confusing the issue if you start giving the elements of the underlying crimes in a conspiracy instruction, because the conspiracy is the crime. The agreement is the crime. We've been given the jury instructions from the Supreme Court, and nothing in there says anything about the listing out the elements of the underlying crimes.
Okay, and I appreciate your response. And the next issue I had is back to what Mr. Thomas brought up also under the statute that sets out the punishment for conspiracy. It's whatever the punishment is, as it states, for the crime or offenses they combine to commit. So if there were a guilty verdict returned on count 1 and or count 3, what do you believe is the statutory required maximum penalties for that offense, where you've got one offense that's only a 14-year maximum, one is up to life in prison or death? Do you pick the higher one? Do you pick the lower one? Does it matter? Do you pick both? Could they run consecutive? Those are questions I have also with these two separate different offenses, and going to what would a punishment be then if you got there?
You know, I don't think it's that confusing. I think they're punishable by the underlying sentences. So they can receive the death penalty for conspiracy to commit murder. And I think that's well established. And I think in this specific case, if the jury is to find them guilty here, the ultimate punishment for that is the death penalty. And I think when you just look at it in a common sense approach, that lower sentence is swallowed up in the higher sentence anyway. And so I don't find that to be an issue. I think the statute is clear. I think the statute even, it uses the plural with the word offenses as well. So I think it already contemplates that. I think whatever the higher one is the one that controls.
Okay, I appreciate your response on that question as well.
Any other questions?
That's the only questions I have at this point.
I would just end, again, Your Honor, this is not, we disagree that this is confusing. And without going into the grand jury proceedings, the grand jury didn't have a problem with it. I don't think a jury will, a trial jury will have a problem with it. Because again, if you really break it down to what the crime is, it's not that confusing. The crime is that they agreed to murder someone and steal money linked to that person. And the crime is the agreement and an overt act. And as long as we establish that, then the jury can make the finding either guilty or not guilty. And I think when we start talking about introducing all the other elements, I don't know that there's any legal rationale or authority that provides for that. Again, I haven't found any. Upon receiving, I would note that the defense hasn't given any authority for that. And when I received their brief we researched this before we ever put this in front of a grand jury, researched this issue, and then when we received their brief, we went back and researched again. I haven't found any authority that says that's the case, that we need to do that. And so based on that, we would ask the court to deny the motion. Thank you.
All right, thank you, Mr. Wood. Mr. Thomas, would you like to present any rebuttal argument?
Just a few points, Judge. I'm a little bit concerned that the state is indicating that they researched this issue prior to presenting it to the grand jury. So I've never done a grand jury. Okay, I was a prosecutor for a few years in Bingham County, but I never did a grand jury. So I'm not really familiar, and as are most attorneys, not really familiar with the process of the grand jury. But my understanding of a grand jury is that you present them with evidence, they go back, they deliberate, they decide what they want to charge it with, and then they come back to the prosecutor and say, these are the charges we're willing to commit, to indict this person on. What Mr. Wood is intimating, I think, is that They decided what the charges were going to be. They presented the document to the grand jury and asked the grand jury to just sign off on it. And so I'm not sure that that's appropriate. I'm not sure that that's the way it should be. And I don't know. And I probably will never know because the grand jury deliberations are secret and I'm not privy to those deliberations. But that's one thing that I kind of raised concerns with me is that perhaps this grand jury was led down a path that they weren't prepared to sign off on. If I'm confused, if the court is confused with counts 1 and counts 3, I don't know what the grand jury would think. I'm assuming that they too may be, at least 1 or 2 of them may have been confused. The second thing I have is that, the state is relying upon this Fowerk versus United States, a 1919 case, where it indicates, and they quote it, the conspiracy is the crime, and that is one, however diverse its objects. When you read the actual opinion, it's a very short 6-page opinion, well written, but you can tell that it's very political. It's a very political opinion regarding the war that we were about to go into, and there were issues there. And so I think that the language that they took out of there, perhaps not taken out of context, but we need to look at it in what the surrounding circumstances were at the time. I mean, we were about to go to war. The person that they were filing this charge against was the person that owned a newspaper in Missouri, and he was writing things that were bad for the war effort. And the Supreme Court of the United States, I think, latched onto that. And so I think we should take that case and that particular citation that they're heavily relying upon with a grain of salt, or at least I would ask the court to review that case. And I'm sure it will. I'm sure it had that all in mind, and maybe it has already. But I would just, I lay concern upon that, upon the state relying upon that particular case and upon that particular statement in that case where they're relying so heavily upon that. Other than that, Your Honor, I have no objections, or no, I have nothing further.
Okay, thank you for the argument, Mr. Thomas. So in this particular motion, then the court will also take that matter under advisement, do some additional research and review your briefings, and consider the arguments presented here today. The court will issue a written decision on the second motion as well. So I believe that concludes the proceedings for this morning. Mr. Thomas, Mr. Archibald, is there anything further from the defense today?
We have a matter to take up with the court under seal. We don't have anything more in public.
Okay, we'll take that up after. And Mr. Wood, anything further today from the state?
No, thank you.
All right, if everyone will give me just a brief moment, I want to consult with the bailiff and then we'll conclude the hearing. All right, at this time, if everyone can remain seated, we're going to have the defendant taken from the courtroom, along with counsel can go with her if you'd like, and then we'll conclude the hearing. So once that's complete, I'll advise the audience when you're allowed to get up and leave. So we can go ahead and go off the record at this point. And I appreciate everyone's consideration of the court rules today and the way you've conducted yourself, and this hearing's concluded.
All right, so there we have it, you guys. Now they're going into their little secret meeting. So a lot of you are asking, what the heck is he talking about? In a way, I do understand what he's saying. I'm going to try and explain it the best way I can. They're saying by them grouping the conspiracy charges together with the murder charges as a whole, instead of separate charges for each conspiracy, they're saying that how is the jury going to find their decision? So say the jury, and I'm just going to give an example. say the jury feels that there's a conspiracy to commit the murder of JJ and Tylee, and a conspiracy to the grand theft when it comes to Tylee, but not JJ. You know what I mean? So they have to be individual. But I mean, going to this extent, saying I want to go back to the grand jury and have them do a probable cause on each conspiracy charge and on each murder charge, I don't think it has to be done with like that. I think when the judge instructs the jury, in those instructions, there can be the murder charge, guilty or not guilty, the conspiracy to commit murder on JJ, guilty or not guilty, conspiracy for grand theft regarding the money she got from JJ, guilty or not guilty, and then do the same for Tylee. So I do believe in the instructions, they could be separated so the jury clearly understands that just because you may not find her guilty on one conspiracy, but you do on the other two, etc., that they're not at a standstill and just saying, well, we're up in the air about it because we can't agree on each individual. So I do believe at the instruction, the judge, the easiest way to do this is that the judge would make separate instructions on each. So the conspiracy to commit grand theft regarding JJ, the conspiracy to commit murder for JJ, the conspiracy to commit grand theft in relation to Tylee, and the murder, the conspiracy to commit murder. They could list those individually. So if they don't find that there was a conspiracy with JJ, they could say, no conspiracy regarding the grand theft, but there was conspiracy for the murder, and she actually did commit the murder, yes or no, to each one of those. So I do think that that would be, I'm hoping that would be the judge's ruling on it. But what I'm thinking is, from what I'm hearing from the defense attorneys, is they want a probable cause hearing on each one of the conspiracy charges. So they want probable cause for the conspiracy for the grand theft regarding JJ. They want a probable cause hearing on the conspiracy regarding the grand theft regarding to Tylee. Then they want another probable cause hearing on the conspiracy to commit murder on both cases individually, and then probable cause for each murder. So it's like they're trying to get a probable cause hearing on each charge instead of on the conspiracy altogether and the murders altogether. So I do believe that this could be when the judge gives his instructions to the jury at the end. I think that he could make it quite clear there of what you are making your decision on. So that would be my instruction. Okay, to the jury regarding JJ. Did she commit the murder? Yes or no? Do you believe she committed the murder? Yes or no? Do you believe she committed to conspire to commit the murder of JJ? Yes or no? And then another box for, do you believe she conspired to commit grand theft? Those would be 3 boxes that they would have a chance to rule on or make a decision on. So they could check, yes, she murdered JJ or was involved with it. Yes, she conspired to murder JJ, but they don't think she conspired to the grand theft regarding JJ. You know what I mean? So each one is going to be decided individually. I don't think this has to go back to the grand jury. I don't think any more taxpayer money has to be wasted on doing probable causes for each of those charges. And that's what it seems to me like the defense is wanting. They want a full probable cause hearing on each charge individually. I think they're saying that I don't know why they would get this, but I think that the defense is kind of thinking, well, you know, they sent this indictment back for all her charges based on all the charges grouped together on a whole instead of individually. So it's like, it is what it is. Those are the charges. They did say the conspiracy and grouped it together. They did group the murder charges with the conspiracy charges to come back with an indictment. But they can't be 100% sure on what the grand jury was thinking because it's done in private. So I think that he is more looking for more information, if you want my honest opinion. And you guys know I worked in the legal field for over 30 years, even though I'm in Canada, finding out information and stuff like that, it's across the board. It doesn't matter what country you're in. I do believe that he's going on a fishing expedition because he wants to hear what the grand jury had in front of them to make the decisions they made. So the only way for him to do that is to either send it back to the grand jury and have them do this individually, or ask for a probable cause hearing on each charge individually, where they would have a chance to argue their points on each individual charge. It would be open to the public and everybody would be able to see what the prosecution has on each of those charges. So I don't know what the judge is going to decide. He's taken both of these things into advisement, which means he's going to go over this in chambers. It could be a week, it could be 2 weeks, it could be a month before we know what he's going to rule on this. Is he going to send it back to the grand jury? Is he going to agree to do probable cause hearings on each charge individually, or is he going to leave it the way it is? So that's what we've got to look forward to regarding that. Now, I see in the comments, a lot of people are asking about the Chad thing. I do believe that strategically, John Pryor agreed to the DNA testing. And I feel he did that as to not give up their hand to Lori's side. He did not, I don't believe that. If I was his lawyer, I would not want him in the same room as Lori until the trial started. And I'm going to give you an example why. Right now, Lori is keeping her mouth shut. She's still thinking, as you can tell, she still had her a wedding band that she had made herself in jail. She has that on, so she's still in love and feels she's married and they're la la land. I believe right now, Lori still thinks that they're in this together. They're going to protect each other. They're going to throw all the blame at Alex and this and that. John Pryor does not want to put Chad in the position to have to face Lori, where he's totally ignoring her, not looking at her. Sorry, no little lovey laughs or smiles towards her, totally ignoring her. They don't want to give Lori any heads up that they're about to put her under the bus. That's what I believe, my honest opinion. Sorry, you guys. My allergies are through the roof again. Has been for the last few days. So that's why I believe the only reason John Pryor agreed to this, to let go of his motion for this consumptive DNA testing and allowed it to happen. So that's the best that I can explain. I know some of this mumble jumble jargon and citing other cases and stuff like that confuses a lot of people. It is confusing. I was kind of shocked a little bit that he brought up a wartime kind of case that he cited, but I think there could have been another case that he could have cited that was more aligned with the case that he's doing. He admits that he's never done a trial that came from the grand jury before, so he doesn't quite know how that works. So I don't know. I just think to make things easier for everybody, I think it should be left to the charge to the jury, and that the judge makes it clear that they are going to rule individually on each of the charges. You got a box that you can check guilty or not guilty for conspiracy to commit murder. You've got a box that you can check individually for conspiracy to the grand theft regarding JJ. You've got another box you can check for the actual murder charge. And that goes then the same for Ty Lee. So I do believe if they give the jury the three options on each individual, JJ and Ty Lee, I think that it could be pretty straightforward for anybody to understand. Yeah, they're very restricted. And like anybody that makes any kind of outburst or like you say in this, Sherry, any gasp or anything that they can be thrown out of the courtroom. But yeah, she sits there, and when she's giggling and stuff, you guys, and the big smiles, I believe in her little brain, she thinks that the judge is reprimanding Rob Wood for her. It's like, haha, there you go. See what the judge just said to you. She does not like Rob Wood at all. But I do feel like her smirks and her smiles face. Ha ha, see, you think you can just say what you want. Well, the judge just told you, didn't he? It's like, oh my God, woman. But she did look heavily medicated. Yeah, I do believe, like, I got like that sometimes too with really high profile cases. Some bail hearings that I had to do for certain individuals that were very well known, very violent people. It's like you're more concerned about your surroundings and watching what's going on in the court, because I'm telling you, I've seen some pretty bad stuff happen in court. Like, is this guy going to come over the glass and attack me because I didn't say what he wanted me to say for his bail hearing? You got to constantly be on guard. And then when you're trying to do your best, because as you go up to do a bail hearing, your client may say to you, okay, well, this and that and this and that. Now I want you already know what you want to say to the judge. You've rehearsed it and everything else and gone over all the points that you want to bring out. And then you're throwing a curveball, and now you've got to incorporate that in there. And your mind's just going a million miles a minute. And you usually got about 5, 6, 7, 8 cases on your docket for the day that you got to get up there to defend or do bail hearings or whatever. When you get stressed, you tend to lose your words. And so I think that this lawyer is a good lawyer. I think he was just put under some pressure that he's not used to being under. Yeah, she laughed and shook her head, and like, yeah, she did. She looked rough. There's no Botox in jail. Looks like they ran out of colored newspaper or whatever she was using for lipstick. Oh, thanks, Summer Dawn. No, thank you. I am now retired from all my legal stuff. Done. It's very stressful. It's a very stressful job. And I wasn't a lawyer. I was only a paralegal. I did do bail hearings and stuff like that. But it is very stressful. It's a very high stressful job. I'm telling you. So I'm glad to be done with it. And Sarah Adams, I'm in. And look at you guys. I agree. So, and it's only you guys, because I worked in the legal field for so long that I can read into a lot of things that are going on. It's not that, if you guys, really, if you could replay it and watch it, you'd pick up on it yourself. It's a lot of this, except for the mumble jumble that they use, and citing other cases and stuff like this. And how does that apply? And how are you going to use it to apply that to your case? How can you mince your words so it sounds like that applies to your case, even though it really doesn't? There's a lot of fandangling going on when it comes to lawyers and how they present stuff and how they use and cite other cases. They're not going to tell you the whole citation. They're going to use the parts that are to their advantage. And it's up to the other side to find something to counteract what they just used in that. So it's a lot of gameplay, and I'm telling you, that's why the liar. Let's call my liar. There's a fine line on what you can do, but you do it to that line because you're working for your client, whether we like it or not. You push it to that line and stop just before the line. You don't cross the line. You stop just before it. Now you take somebody like Mark Means, who doesn't have that line and doesn't really care about that line, and takes it to the next level. And that's why he was pretty much laughed out of court. It's crazy. So that's what we got. They're gone into secret now. Some more secret hearings. There is somebody who has filed motions to the court to have everything put on the table. In, I believe it's this case. This case here. She's saying there's too much done in secret, too much being sealed. We as the public should be able to hear all this, and she's taking it to court. So we'll see how that turns out. But yeah, still no tears, no remorse. It's like, Your children are gone. Above everything else, your children are gone. You know? I don't know where he is now, Rosie. I really could care less. Oh my gosh, Miss Jones. That's sad. Sarah, we already went over that. You'll have to rewind. I've explained all that. And again, you guys, this will not be, once we stop the live, it won't be available usually for about 20 to 30 minutes for it to all upload to YouTube. So if you do try and go back and watch this from the beginning and you can't get to it, give it a bit. Within usually 30 minutes, it's back up. So from StreamYards and that, it takes some time to get everything uploaded to YouTube. There's my sister. Thank you for putting up the links. And don't forget, you guys, use promo code. I gotta look it up again. Save 15. I'll put it in here. Save 15. That is the promo code you can use on in my store. You save 15% on all your purchases, the clothing and everything. And this is only until Saturday, so Friday at midnight. Because all the clothing is going to be removed because I'm going to be having new designs up. They will be back up probably in, I'd say maybe October. We're redesigning all the clothing lines. So if you do want anything that is there, there's you can save 15% right now until Friday at midnight, using the promo code SAVE15 at checkout. So if you do want any of that merch, you're going to have to go and get it before Friday at midnight because it will be gone after that. And then the new line will be launched probably, I'm thinking October, sometime in October or November. Thank you, Sherry. I love you guys too. So another thing I'm just going to bring up outside of this case, Adventures with Purpose has agreed to come and help search for Kylie Rodney. They will be here Friday night. If Kylie is not found by Friday, they are going to be coming. Apparently, they have been asked by a law enforcement agency. I know a lot of people from YouTube and a lot of the subscribers have emailed them and commented and asked them to come. But for them to come to an open investigation, one of the law enforcement agencies would have had to request it. Obviously, that has been done. They're not releasing which agency requested them, but one of them did. For them to be able to come into an open investigation, they will be at the site Friday night. Now, they probably won't start doing any searching or anything until Saturday, but they will be in Truckee on Friday. So that is big news. Like, they have the state-of-the-art equipment. I'm not saying or condemning any of the law enforcement agencies that are there already. Law enforcement agencies have limited budgets and stuff like that. So maybe they don't have the high-tech equipment that somebody like Adventures with Purpose would get, because this is what they do 24/7. So they want the best equipment, whereas local law enforcement and stuff like that probably could not afford to purchase that. It's not in their budget. They do have sonars, but I don't think it's as high tech as what Adventures with Purpose has. So they have been called in. They have been given the okay by one of the agencies. We don't know which one, and they are not disclosing which one. On beanie merch yet. Yeah. I'm going to see what happens with that. See if I can get somebody to figure out how to do that. But I might be getting that done, yes, for the beanies for this winter, because everybody's asking for the beanies. So yeah, so I'm excited for Adventures with Purpose to get there and use their equipment to search. It's going to be interesting. Yeah, and it's like there's no shame in asking for help. If you know, like they want, their main objective is to find Kylie. So if they have to call in somebody like Adventures with Purpose that has higher tech equipment than what they have, why wouldn't you, right? Their main goal, all of them, is to find Kylie. So I'm happy that they're coming. Oh, thank you, Sarah. I try my best. I try my best. Oh my God. A kid just walked by the front of my house on the sidewalk with a fishing box or something he had in his hand. It looked like a fishing box. Looked exactly like Jagger, Kylie's ex-boyfriend. And I'm not saying that it's him. I'm just saying that kid looked like him. Yes, Des has bought at least one of everything. Believe me. She's got 2-3 blankets. She's got umpteen pullovers, umpteen zip-up hoodies, the shirts. She's got a wide variety. If you have purchased anything, send me an email with a picture of it, of you having it on, and I will post that in my community tab. Yeah, there's some like, and Summer, that's why I say I don't want other, like putting Adventures with Purpose. I'm letting that go because they're not part of any drama channels or anything like that. They're there to search and help. That's why I say I don't want other channels mentioned in my chat because it brings drama. And AK and what he's doing is phenomenal. And now they're starting to attack him too. So that's why I don't like my video that I did yesterday. It's not often you're going to see me do that, but I was heated. I have a granddaughter, Kylie's age. Okay. I was heated and I needed to get that off my chest because it was just eating me alive. But that's why I don't do things like that because I don't need people coming over here and starting attacking me and everything else. So that's why I leave. I say, please do not mention other channels, other sources, anything like that in my chat. Any of the conspiracy things going on, I don't know. Absolutely not. I'm not going to be dragged into it. That protects me, and it also protects my subscribers because I do not allow anybody to come in here and start attacking my subscribers either. I believe everybody is entitled to their own opinion if you do it respectfully and without judging or attacking my subscribers or the victims' family members. I have no problem with you disagreeing with me as long as you do it respectfully. So that's why this is no drama. You start drama, you start attacking, you're gone. So okay, let's just leave that go, Summer. See now, and this is what I mean. Let's just let it go, please. I don't need the drama being brought over here. So please just let's let it go. Oh, thank you, Ms. Jones. Yes, and that's why, I mean, I get this a lot. Like, thank you, Willow, for keeping this a safe place for me to land. And it will always be that way. I don't allow anyone, I don't care if you've been here a year or 2 years. I've been on YouTube now 2 years. I'm not going to allow anyone to attack anyone else, regardless of how long you've been here. You do not have the right to attack or bully or insult or anything like that to anyone, not here. Okay, Summer, I've asked, please stop. I love you, girl, but please stop. Stop mentioning. I don't need this going somewhere where I've got to start getting upset. So I've asked to stop mentioning it in chat. Please do so. Yeah, her smiling was, I don't know, man. She just irks me. She just irks me. Yeah, I'm glad I missed all the drama too, because I'm not going to be drawn into it, and I'm not going to have it on my channel. Rosie says, so do you think she was pulling a Letitia? I don't know so much about pulling a Letitia. I think she just, I just think that she can get away with everything she's done. I think that her involvement with it, she really tried to keep herself behind. Like, you know, when Charles got shot by her brother, she took off, like tried to distance herself from it. She gets this anger and that going in these men, and then detaches herself from it so she can't be held accountable. And I think that this is going to be her way of trying to detach herself from even these charges. That's what I think she's doing. If you can't prove that I was at that property when my kids went missing, if you can't prove that I had my kids handed over, if you can't prove me being there when they were murdered and buried on my husband's property, then you can't find me guilty. She thinks that she's going to walk from all this because I don't think they can pinpoint her there when it happened. And I'm not saying by any means that she is not and she shouldn't be held accountable. She just right from the beginning made sure she had kept herself at that distance from everything that was going on. So she created this storm. And then once that storm exploded and the lightning started striking, she was already out the door and down the street away from it. Thank you, Dad, so much, my lovely sister, for your super chat. Thank you. Thank you. They help keep the channel going and help me keep all the upgrades that I've got so I can keep doing these live streams and everything. So it does go right back into the channel. So thank you very much for that. And I appreciate you too. And I appreciate all my mods and all my subscribers. Thank you. Thank you so much for that. I actually think that there was a plan. There was a plan between her and Chad. We're just going to blame it all on Alex, blah, blah, blah. But I think Chad's taking a different road. And I think he's going to put it all on Chad and Lori. And that's why I think he wanted to keep them separate. He doesn't want them in court together until they're actually at trial. Because Lori would be googly-eyeing, and if Chad doesn't look at her or googly-eye her back or anything, she's going to know something up, right? She's like, why, honey? Why are you not looking at me? Look at me, honey. Yeah. Yeah, she thinks that she's pulled one over. I really do think that she thinks that she has distanced herself enough that they can't prove that she was there or that she had anything to do with it. And she's going to say, well, I didn't know they were dead. See, that proves that I had nothing to do with them. That's the only reason I kept taking their money, because I didn't know they were dead. That proves that I didn't know they were dead or was part of that, because I kept taking the money thinking they were alive, and that actually, you know, Chad and my brother told me they put them in hiding to protect them. Maybe she was giving that money to Chad, and Chad was saying it was for the protection of the kids and she had to help support them. We don't know. We don't know what she's going to come out with, but I wouldn't put it past her. I was giving that money to the people who were taking care of my kids. My kids were safe. I didn't know they were dead. She probably still doesn't think they're dead. Who knows? Who knows what she's going to say? But I think that the Lori's defense team are really going to have to do an about face when they realize what's coming at them with what Chad's lawyers are doing. I don't think they've caught on yet that Chad is gearing up to throw Lori under the bus. Yes, Chad can turn on her. Chad can turn on her at any time. Look at, give me 10 years and I'll tell you everything. But what I've also heard is that a lot of the top-notch legal beagles that are watching this case and watching things transpire as it goes, a lot of them are saying that this trial is not going to happen in January as scheduled. And the reason being is they're just doing the DNA testing now. It takes a couple months to get the results back, and then it takes at least a while for the defense and prosecution to be able to go over those results and form an opinion from those results and get their crap together with those results. I don't think it's going to happen in January. And if that happens, like I said at the beginning, Lori did not waive her right to a speedy trial, but being that it was only 60 days before the trial was going to start from the time that she would have initially in October had her trial, they didn't think it was atrocious. So they figured that they could get away with not, giving her right to a speedy trial because it was only 60 days, which was reasonable. But if they put it past that now, she can use that for an appeal because she has not agreed to she's not agreed to waive her right to a speedy trial. So if this is pushed out to next summer or next fall, like I think it will be, she's going to have an appeal. She's going to have some grounds on her appeal there. So thank you again, Des, for that super sticker. I appreciate it. Thank you. Thank you. So Miss Jones is living in the area where Chad lives. And she says the whole community was worried about these kids while they were married in Hawaii. Yeah. I knew that they were already gone. That's the intuition. Well, they have to prove that, right, Sarah? I believe they did, absolutely, but that's not what she's going to say. Idaho's dragging their feet. Kay and Larry want to bury JJ. He's still frozen at our hospital, and it's time to let them run. Oh my gosh. Oh crap, my chat just went flying here. Could very well be, Sherry. I'm saying that regretfully, but if this is the case, then yes, it could be next summer, next fall. Every little bit helps, sister. So thank you so much. I appreciate every single super chat, super sticker, no matter what the amount is. I appreciate it. And like I said, it goes to help keep the channel up and going. StreamYards is getting really expensive and YouTube's taking so much more now. It's just crazy. So every little bit helps. So thank you so much for that. And I appreciate it. So you personally know Nate Eaton. He's wonderful. He sounds like a really stand-up guy. So Susan, I've asked, please, that you don't mention other channels ever. Please don't do that. Thank you, Rosie. Thank you. Thank you. And like I said, YouTube is really cramping down on certain things. And I'm not going to get any strikes or anything like that from YouTube because of what's being said in my chat. I'm just not going to do it. But yeah, I really do think that this is not going to happen now until summer or maybe even fall of next year. Letitia, I'm glad you mentioned that. History Underfoot. Letitia is back in court on August 25th, and I will be covering that just like I did here today with this one, because I do believe that that one can be streamed also. And if it can't be streamed, I will be giving you a live play-by-play what's coming out of the courtroom. But I do believe I seen somewhere that I can live stream that one also. The 25th of August. And I will be covering that. I will be starting at 3:15 Eastern. The hearing is set to start at 3:30. I like to get online about 15 minutes before to give you guys a rundown of what's going on and what's going to happen at that hearing. Her evaluation is back, and they are going to be discussing that, hopefully setting a trial date at that time. So you're not going to want to miss that one. And I will be covering that too. Yeah, both JJ and Tali deserve a proper burial, and right now their remains are still in the freezer. No problem, Miss Jones. And like I said, I will be covering that live too. So I'm going to let people know. I see a lot of people just coming in now. Once I'm done the live stream here, it will be unavailable for about 30 minutes, and then it will be back up. It takes time for StreamYards to get all the live chat and everything uploaded to YouTube. So it does go ghost for about 30 minutes. So it will be back up. Okay, so you guys, with that being said, thank you guys who did give super chats. Thank you so much. Your super stickers, I appreciate it. It helps the channel, and it shows me your appreciation. So thank you very much. Thank you for everybody being here watching. Please give the video a like, share it out where you can. That helps just as much. I'm expecting any time now to get my 1 thumbs down that I always get. I have a hater. I do have a hater, which is okay because even their thumbs down helps me in the algorithm. Thank you. And it gives me a view. So thank you. Thank you for your thumbs down. Doesn't bother me one way or the other. I'm still going to continue to do what I do and bring this to you guys because I love ya. So thank you everybody for being here. Thank you for your patience throughout it. Much love right back to you guys. Thank you for my mods for being here. You guys are amazing. Before I go, happy birthday in 2 days to Marie Burks. It is her birthday on Thursday. I don't know if I will be going live again before Thursday, so I want to say happy birthday to you. If anything does pop off in any of the cases I follow between now and the next time I go live, I will go live and bring it to you. And if I don't go live, I will keep an eye on my community tab. I put a lot of information that's coming out there also. So with that being said, you guys, love you to the moon and back. Please take care of yourselves. Please stay safe. Please give this video a like. Please share it out where you can. Please subscribe if you're not subscribed so you don't miss anything. Hit that little notification bell. You'll be made aware each time I go live and when new videos are posted. Okay? Till the next time, you guys, please take care. Love you to the moon and back. Bye-bye for now.